I'd now like to ask former Attorney General Ramesh L Maharaj, Senior Counsel, to share his thoughts with us at this time.
Thank you very much, Mr. Chairman, members of the Roundtable, members of the media, and good afternoon to all, and good afternoon to Trinidad and Tobago. I am here this afternoon to defend the Constitution of Trinidad and Tobago, to defend democracy, and to defend the rule of law. What has happened in the Parliament with the leader of the opposition is not an issue which affects the leader of the opposition alone or members of the PNM. This affects every individual in Trinidad and Tobago. It was an assault on the Constitution, on the rule of law, and on democracy. We must understand that the Parliament is one of the three arms of state. The other two arms are the executive arm of the state, and the other arm is the judicial arm of the state. The Parliament is a forum for the people, where the rights of the people are to be defended, and the leader of the opposition represents the people of Trinidad and Tobago. Under the Constitution, he is there with the opposition to defend the rights of the people, not to defend only the rights and members of the PNM, or the rights and members of the UNC, or of the Congress of the People, to defend all the people of Trinidad and Tobago. So when a government under the Constitution is governing the country, the people depend upon the opposition in the Parliament to keep the government in check. So when the opposition is muzzled, the people are muzzled. Not only PNM people are muzzled, UNC people are muzzled, COP people are muzzled, and people who do not belong to political parties are muzzled. So if it is that the Prime Minister and the members of the government took steps to unlawfully remove the leader of the opposition from the Parliament, is as if the government has declared war on the people. It's as if the government has decided to use its power to overthrow the Constitution of Trinidad and Tobago and declare war to every individual in Trinidad and Tobago. Make no bones about it. This was a declaration of war against every PNM member in this country, every UNC member, every COP member, every partnership member. And that is why I am here this afternoon. I am here to defend the Constitution. I decided to make some notes on this matter because I think it is very important. And I want all those who are listening on the electronic media, young and old alike, to understand clearly what has happened here in Trinidad and Tobago. When a government decides to control the opposition, that is a government which is either dictatorial or is becoming dictatorial. When a government becomes dictatorial, human and fundamental rights are not enjoyed, the rights of people are not enjoyed, and the opposition is not tolerated in any parliamentary system. When a prime minister uses the power of control of the majority of members of the House of Representatives and acts in violation of the principles of the common law, the principles of the requirements of fairness enshrined in the Constitution of Trinidad and Tobago, acts in violation of the principles of the Judicial Review Act of Trinidad and Tobago and all the principles of public law, to remove by suspension the leader of the opposition from the House of Representatives, it is not only unconstitutional and unlawful, null and void and of no legal effect, but it strikes at the foundations of democracy in our country, strikes at the rule of law and parliamentary governance in Trinidad and Tobago. due process of law is an important safeguard which is enshrined in the principles of the common law, in the principles of the Constitution, and in the principles of public law in our country, to act as a check against the exercise of arbitrary power by a government and public officials. Due process of law has to be followed by the Parliament. Under the Constitution of Trinidad and Tobago, the guardian of the rights of the people is the judicial arm of the state. Parliament, the judicial arm of the state, and the executive must observe constitutional rights. So it was the constitutional duty of the government to observe due process of law. The leader of the opposition was entitled by the Constitution and the laws of Trinidad and Tobago for him not to be suspended from Parliament in respect of the disputed issue of the authenticity of emails without that issue first being determined in accordance with the established principles of due process of law and the rules of natural justice by having it first determined by the Committee of Privileges of Parliament. It is only after the Committee of Privileges determine the issue and a report is sent to the Parliament, which is debated in openness of Parliament, that you could then have a vote. So the vote in the Parliament was premature, and the vote in the Parliament dispensed with the law because the government had the majority in the Parliament. At the Committee of Privileges, the leader of the opposition would be entitled to have legal representation. The leader of the opposition would be entitled to cross-examine himself if he wants the accusers. The leader of the opposition would have been entitled to call evidence, for he himself to give evidence, to call witnesses, even to call an expert, and even to call evidence to show that the contents of the emails are substantially true. And that is what due process of law required in this matter. There was no lawful power of the Prime Minister or the government or the Speaker to permit this travesty of justice and the naked violation of the Constitution of Trinidad and Tobago. They all in that house that day should have remembered they took an oath of office to uphold the Constitution and the law. So what we had in Trinidad and Tobago was a government violating the Constitution of every individual in Trinidad and Tobago represented by the leader of the opposition. This was not a case where the House of Representatives was dealing with a situation where a member of the House of Representatives, in the presence of the House, in the full view of the House, is alleged to have committed a breach of privilege. In that kind of case, it is open for the House to deal with the matter at that time. And you would have seen situation like that in Trinidad and Tobago. This was a case in which the allegation was that there were emails. In those emails, serious allegations were made against government ministers, including the Prime Minister and the Attorney General. The people called for an independent investigation. The Prime Minister refused. The Prime Minister sent it to the police. So the question arose, according to the Prime Minister, is whether these emails were authentic. You could not determine that by members of the Parliament debating it in open Parliament. There had to be evidence. There had to be evidence. There had to be expert. Probably Google would have had to give evidence too. Could have been called as a witness. This is not the kind of case where the Prime Minister could produce a letter from a lawyer and say there's a letter from Google, but do not produce the Google letter. This is fiddling with public office. So we have to understand what the government has done is that it's created its own inquiry through the Prime Minister. They have done that, dispensed with the police, dispensed with the Integrity Commission, and conducting their own investigations. The Prime Minister, therefore, deprived the leader of the opposition of his right to cross-examine persons, of his right to give evidence on his behalf, of his right to call evidence on his behalf, and all the processes of due process of law. Nakedly, unashamedly denied the leader of the opposition that. And the leader of the opposition is an important office under the Constitution of Trinidad and Tobago. And remember that if this precedent goes unchecked, that by this precedent, whether now or in the future, any Prime Minister can overnight summarily dismiss the entire opposition from the Parliament. And you can have a one-party state in Trinidad and Tobago for 5 years until a general election. That is how serious this precedent is in Trinidad and Tobago. But it is my view that the core issue to be determined, the gist of the issue to be determined in Emailgate is not whether the emails emanated from the email addresses stated in the emails. It may be that some of those addresses were not correct. And for many reasons, it may be. But the real core of the issue is whether the emails handed to Dr. Rowley or sent to him contained true matters, whether they were true, substantially true. And I pose certain questions. Was it true that the DPP's office was bugged in any fashion? The emails talked about that. Was it true that there was a conspiracy between government members to get rid of a journalist? Was it true that a request was made by those in power to get the DPP out of office and see that whether he could be appointed a judge? Was there any evidence of official corruption contained and referred to in the alleged emails? As I understand it from the people's point of view, what the government has to prove to the population is that the contents of that email, of those emails, were not true. And we know as a matter of fact, if you do not know, I know and some people know, that some of the contents of those emails are true. So Emailgate is a very serious issue in Trinidad and Tobago, and the people should not allow the government to bury Emailgate by the Prime Minister taking this step to try to silence the leader of the opposition and the opposition. The efforts which are being made by the government to reduce the Emailgate issue as to whether the emails themselves are from fake addresses without concentrating on the core issues to be investigated must increase the curiosity and distrust of members of the public. The efforts and actions taken to silence the opposition leader on the Emailgate issue and to remove him from the parliament would lead a reasonable person to believe that government wants at all costs to bury Emailgate because the government is worried about the truth in the emails. It is curious that on the same day the due process of law was denied by the government to the leader of the opposition in respect of Emailgate, the same speaker and the same government facilitated due process of law to have the Committee of Privileges investigate the alleged fake letter of Sir Henry Ford. In the Huawei matter, that is the alleged insider trading issue. It is significant that within minutes, on the same day, you had two different rulings and two different actions from the same players in the state. The undemocratic and unconstitutional action of the Prime Minister and a government to suspend the leader of the opposition is a precedent which the people of Trinidad and Tobago would not be prepared to accept. It has to be remedied, and it has to be remedied politically. It has to be remedied politically. If it is not remedied, it would affect freedom of speech of members of parliament in the House. It can inhibit opposition members from presenting their parliamentary debates, contributions. Take an example. If this is correct, then a member of the parliament can be reading from any of the authentic newspapers. It could be an authentic copy. And the speaker can say that is a fake, and then call upon a member to suspend the member of parliament with no investigation. That is what can happen in the Parliament of Trinidad and Tobago if this precedent goes unchecked. So it is for these reasons that I believe that this is not an attack only on the leader of the opposition. I consider it an attack on everyone in Trinidad and Tobago. It is an attack on me. And I am attacked by the partnership government in the breaches of the Constitution. Constitutional values which I tried my best as a member of parliament to uphold for the benefit of the people of Trinidad and Tobago. And I do not intend to rest until the government of Trinidad and Tobago takes steps to remove this injustice to the people of Trinidad and Tobago and to the leader of the opposition. Thank you very much.